Okay guys, so as I told you last time, I will record a lecture and then post it in our FB page. So here it is, no? During this Easter day. So the topic will be double Jeopardy. Okay, so if you look at Section 21 of the Constitution, it's very clear that no person shall be placed in another jeopardy. And if we are talking about jeopardy, we are actually referring to the danger of being imprisoned or detained for the second time. So, it's very clear that double jeopardy refers only to criminal proceedings, or to those proceedings which the result might be imprisonment. So there's no double jeopardy in terms of civil cases or administrative cases. And in order for you to know whether there will be a danger of violating double jeopardy, the first consideration you have to make is, how do you know that the first jeopardy has already attached? And it's very clear in the Constitution that there are 4 requisites in order to determine whether or not the first jeopardy has already attached. And the first one is, you know very well, there must be a valid complaint or information. So, in our discussion before, I was explaining to you that complaint or information is the charge sheet or the document being used by the government through the prosecutors to charge you of whatever crime you have violated or a person has violated. So, that information must be valid, because if the information is not valid, then the first jeopardy will not attach. And how do you know that that information is already valid? Meaning, all the requisites or all that must be stated in the information must be there, without which the information will not be considered valid. For example, there must be the signature of the city prosecutor's office or the provincial prosecutor's office, meaning through the head, no? The city prosecutor or the provincial prosecutor. If the signature is only that of the investigating prosecutor without the approval of the head of office, which is the city prosecutor, then the information is not valid. And all the elements of the crime must be stated in that information. Because you know very well in revised penal code, for every crime or for every offense, there are certain elements that must be proven in order for the person to be convicted. Now, if the information does not contain the complete elements, then that information is not complete. It's not valid. Why? Because you cannot be convicted. So no matter how good the prosecutor is, you will not be convicted under that information because the elements are not complete. And remember, during trial, the prosecutor cannot introduce an evidence which is not stated or does not refer to any element in the information. So, for example, if a person must be charged before the Sandigan Bayan, it is indispensable that it must be stated in the information that the crime was committed in relation to the functions of his office. So I will call your attention again, go back to Section 9, Rule 110 of the Revised Rules of Criminal Procedure, so that you will know what are those which must be stated or included in the information. Now, take note, I'm talking about the elements, that the elements must be there. I'm not referring simply to qualifying circumstances or aggravating circumstances. Because if a qualifying circumstance was not included in the information, it will not make the information invalid. No? It will only define what crime is committed. Like for example, if the element of treachery was not stated in the information for murder, and that is the only qualifying circumstance that they want to use, but treachery was not stated in the information, it does not mean that the information is invalid. It simply means that during trial, they cannot prove murder. They can only prove homicide. So, once he is convicted with homicide and he served his sentence, they cannot again charge him of murder because the information actually is valid. So, there's a distinction. You have really to be careful. There's a distinction between lack of element in the information as compared to lack of qualifying circumstance. Another example of qualifying circumstance, for example, minority. They did not state in the information the age of the victim, stating that the victim is a minor, for example. So it will affect no, the penalty later on once the person is convicted, but it will not make the information invalid. Okay? So as far as section 9, rule 110, last time I was telling you that for a valid information to be what it is, then section 9 must apply, meaning that you cannot state there simply conclusions of law or terms which are legalist. No, you have to state there the facts and terms which common people can easily understand. Now, the second requisite in order that jeopardy will set in is it must be filed before a competent court. And when we are saying competent court, we mean court of jurisdiction. And under the rules of criminal procedure and under the law relevant to this, jurisdiction is conferred by law. So, take note that jurisdiction cannot be the result of agreement between two parties. So, the accused and the government cannot agree that, okay, the court of Gimbal, RTC Gimbal will have jurisdiction over the case. No. Jurisdiction is determined by law. And in criminal procedure, you know very well that the basis of jurisdiction is what? Is territorial jurisdiction. So, wherever the crime was committed, then the court which has territorial jurisdiction over the place will be the one to try the case. So, if the crime was committed in, for example, where else? Igbaras. Then, the court of Gimbal, RTC of Gimbal, will have jurisdiction over the case, not the RTC of Iloilo. So, that is as far as territorial jurisdiction is concerned. Now, you have no choice, unfortunately. As far as jurisdiction, you have to memorize it. From the jurisdiction of the Supreme Court, down to the Court of Appeals, down to the Regional Trial Court, Municipal Trial Court, you have to know what are the jurisdiction of courts. Now, take note that jurisdiction is also determined based on the imposable penalty. So, you know very well that if you're talking about first-level courts, Municipal Trial Court or Municipal Circuit Trial Court, as far as criminal cases, the imposable penalty is not more than 6 years. On the other hand, if you're talking about RTC or Regional Trial Court, the imposable penalty is more than 6 years. In addition, jurisdiction is also determined by special laws passed by Congress. So we have now family courts. So for example, if the victim is a minor or the accused a minor, then it is the family court which will try the case, not any other regular courts. There's also a law which gives jurisdiction to special courts like commercial courts, like environmental courts and also agrarian courts. So, if a case has that kind of complexion, whether agrarian, environmental, commercial, then it must be raffled to that specific courts. Now, what's the effect if the court has no jurisdiction? All the proceedings of the court, including the judgment and the decision, is null and void, meaning void from the beginning. That's how important, no, in determining, that's how important that we should determine whether the court has jurisdiction or not. And of course, you will not forget the so-called Olaguer doctrine, no, taken from the case of Olaguer, which was decided by the Supreme Court during the time of martial law. Under the Olaguer doctrine, we know very well that civilians cannot be tried by military courts even during the time of martial law. So, once a civilian is convicted by a military court, his conviction is null and void. So, he will be given again a chance for another trial. However, if a person is acquitted by a military court, then that person can no longer be tried again. Even though, supposedly, the court has no jurisdiction, but because of the operative fact doctrine, that person cannot be tried again because it will place him in double jeopardy. So, kamo na bahala mag-research kung ano ang operative fact doctrine, but I'm sure you know that already. Okay, so take note of the second element. The court must have jurisdiction, or the case must be filed before a competent court. Third, to which the accused has pleaded. No? So the plea is only guilty or not guilty. So wala sang plea nga medyo guilty, mambala malon sa nga how do you enter your plea? Mambala accused nga medyo guilty, medyo not guilty. That's not possible. So there are only two choices. Either you enter a plea of not guilty or guilty. What happen if the accused will not answer? No? Sang ginapamangkot siya sang judge, for example, ano ang imong nga plea? No, gamudlo lang matay sa judge. So, what does it mean? It means that the accused is entering a plea of not guilty. So, under the rules of criminal procedure, the judge will be the one to enter a plea of not guilty. So, why not guilty? Because of the presumption of innocence. Okay? So, considering that there's no trial yet, no, even though he is caught in flagrante delicto, under the fiction of law, he is still considered to be innocent. So, again, I will invite your attention, go back, no, to the right of the accused to be informed of the nature and cause of the accusation against him. Because during arraignment, that's where the accused is being informed of the nature and cause of the accusation against him. Okay? So, during arraignment, the accused must be what? Must be able to understand what is or what are the things being read to him, no? Whether he understands it or not. So if the accused understands only Kinaraya or Latin or Spanish, que horror, that means that the interpreter or the court personnel must read the information to him in that language or dialect. Okay, so I was telling you last time about an accused who is deaf-mute. So if he is deaf-mute, then it is part of the obligation of the court to make sure that he will be able to understand, no, what are being conveyed to him during arraignment. So either the court will look for people who know sign language, like that. Whatever they will do to make sure that the accused really understands, no, the information. Okay. Take note, guys. Because it is a requirement that the accused has entered his plea, you have to be very careful no matter how long the question given to you. If the accused was not arraigned because the case was dismissed before the prosecutor's office palang, or the accused or the case was dismissed by the Secretary of Justice during the petition for review, take note, there is no double jeopardy. So you have to be very careful to dissect or to look at the question whether there was already arraignment or not. So any kind of dismissal at the level or at the stage before arraignment, there is no setting in of jeopardy. Okay. Fourth requisite for jeopardy to set in, the accused was previously acquitted or convicted, or the case dismissed or otherwise terminated without his express consent. Now, take note, this fourth requisite is medyo complicated because the fourth requisite now gives you the different modes of ending the case. So the first mode is he is acquitted. So klaro na, there's no gray area because once you are acquitted, the court will say that you are acquitted. Wala man gambal ang court nga medyo acquitted ka, medyo wala. So it's really acquitted. Second mode of ending, convicted. The same with acquittal, conviction is very clear because wala man gambal ang court nga medyo convicted, medyo wala. No? Okay, so it's very clear. So once you're acquitted, once you're convicted, you have no problem with that. Ang may gray area is the third mode. Why? Because here, the case is dismissed or terminated without his express consent. Okay? So if you're reading Bernas, you might be confused that the case was dismissed without trial on the merits. So may discussion na about trial on the merits. The dismissal was made before trial on the merits. Try to understand the situation here. So if the case is dismissed or terminated without his express consent, then jeopardy sets in. Okay? So what do you mean by express consent here? So when you say express consent, it need not be in writing. It's very clear. Okay? As long as it is expressly made or categorically made in open court, no, before the judge with the assistance of your defense counsel. Okay? So, it may not be in writing. How about if it is in writing? Well, there's no prohibition regarding that. The minimum or the least that is required is the dismissal must be expressly made. And the fact that the defense counsel merely kept silent when the prosecutor was asking for the dismissal, it is not an express consent. Okay? So for example, the prosecutor will say, Your Honor, due to the absence of our witnesses, no, who were all killed by COVID-19, then we ask for the dismissal of the case. Upon hearing that, the defense counsel merely smiled and kept silent. And the judge dismissed the case. Can the case be refiled if other witnesses surfaced and told the prosecutor that they are willing to testify? It cannot be refiled anymore. Why? Because the dismissal of the case is without the express consent of the accused. Okay? So take note, guys. Express consent of the accused. Now, for example, during pre-trial, no, take note, during pre-trial, it means after arraignment. So, after arraignment, for example, during pre-trial, the prosecutor moved for the dismissal of the case. And the court granted it. No? Because excited si judge nga i-dismiss, mauli na siya. No? Because he is afraid of COVID-19 nga naga-approach no, sa iyang court. No? As if makita ay nga nagapalapit. Anyway, so, the judge dismissed the case. Question, can the same case be refiled? The answer is no. Why? Because the dismissal of the case is without the express consent of the accused. Now, take note, that is only during pre-trial. Okay? And when you are talking about pre-trial, they have not started the trial on the merits yet. Okay? So, you cannot say nga, just because nga wala sang trial on the merits, wala sang double jeopardy. No? What's important here is whether or not the dismissal is with or without the express consent of the accused. Okay, so that's very clear. Okay. Now, by the way, ari ko di gali sa library. No? This is the portion of the house nga, syempre, if you want to study, if you want to check, no? Dili ko uli check ang inyong notebook, kag inyong quizzes. Okay, so tapos ko na ang quizzes sa Consti 1, then ma-start na ko sa notebooks, no? So, just pray that no, I'll be able to finish soon. Parang I'll be able to submit your grades in Consti 1, and then I will start checking Consti 2. Okay, so the dismissal is without the express consent of the accused. Now, I will reiterate the rule. If the dismissal or the termination of the case is without the express consent of the accused, that means jeopardy or the first jeopardy has already set in. So they cannot refile the case later on because it will violate the rule on double jeopardy. Okay. Now, as I already posted in our Facebook page, there are exceptions to that. There are exceptions to that, meaning there are at least 3 exceptions that the dismissal is with the express consent of the accused, and yet may double jeopardy. Tinga exception sa because look, ang rule amo ni, if the case is dismissed or terminated without the express consent of the accused, there will be the setting in of double jeopardy, no? Because the first jeopardy has already attached. Nga exception siya because in this exception, the dismissal is with, hindi without, with the express consent of the accused, and yet double jeopardy will set in because the first jeopardy has attached. Okay, the first exception is what? If the dismissal is what? If the dismissal of the case is due to insufficiency of evidence. That's the first exception. So, after the prosecution presented its evidence, usually the prosecutor will say, Your Honor, that's all our evidence, so we rest our case. After hearing that, the defense counsel will make a decision whether he is going to file a motion to dismiss in the nature of the demurrer to evidence or not. So, the title of the motion is Motion to Dismiss in the Nature of the Demurrer to Evidence. Meaning, the defense counsel is asking for the dismissal of the case because the evidence presented by the prosecutor is not enough to overcome the presumption of evidence. A presumption of innocence, The presumption of innocence. So, what the defense counsel is asking the court actually is to dismiss the case even though he will no longer present evidence. Okay? And usually, if you study the rules on criminal procedure, you're given a period of time to what? to submit your motion. Like for example, I remember right, it's 10 days. No? Within 10 days, you have to submit your motion to dismiss. Now, considering it is a motion to dismiss filed by the defense, no? That means that it is with the express consent of the accused. Okay? It is with the express consent of the accused. Now, after the filing of the motion, what will the judge do? The judge will set the case for hearing. So, they will hear the motion. So, the prosecutor usually will oppose the motion, arguing that the evidence he presented is enough to overcome the presumption of innocence. Naturally, the defense will argue that the evidence presented is not enough. What if the judge believes the defense? If the judge believes the defense, that means he will dismiss the case. And if he will dismiss the case, that dismissal is tantamount to acquittal. And because it is an acquittal, it is a valid mode of terminating the case, even without the express consent of the accused. What will happen? There will be the double jeopardy setting in. So they cannot refile the case. Okay. Not only that, they cannot refile the case, they cannot also even file a motion for reconsideration, and they cannot even file a petition for certiorari questioning the dismissal. Because in acquittal, or any mode of termination tantamount to acquittal, there is no motion for reconsideration, there is no appeal, there is no petition for certiorari, that is immediately executory. But of course, there's an exception to that. Later on, I will discuss the case of Marciales. So, I think it's clear to you now what is the first exception. No, remember, it is an exception because the termination is with the express consent of the accused. Second exception, which is the dismissal of the case with the express consent of the accused on the ground that there's a violation of the right to speedy trial. So, you have to go back and review the provisions of Speedy Trial Act. That means that you have to determine whether the delay is unreasonable. And when you say the delay is unreasonable, that means that the delay is arbitrary, whimsical, capricious, meaning there's no valid reason for the delay. Okay, so what usually happen is that during pre-trial, each party, meaning the defense and the prosecutor, are given by the court how many trial dates. So if the defense will ask, for example, for 2 trial dates, and the prosecutor will ask for 5 trial dates, that means that during trial, the prosecutor must present his evidence within those 5 trial dates. What happened if the defense was not able to present his witnesses during those 5 trial dates? So the defense counsel now will move for the dismissal of the case on the ground that continued failure of the prosecution to present evidence already violates the right of the accused to speedy trial. So, if the judge will grant the dismissal based on the violation of the right to speedy trial, that is also tantamount to acquittal. And considering that it is tantamount to acquittal, double jeopardy will bar the refiling of the case. You have to take note, however, that there must be a valid There must be a valid violation or correct violation of the right to speedy trial. Because take note, if there's no really violation of the right to speedy trial because the delay is caused both by the defense and the prosecutor, like for example, the prosecutor got sick or the judge attended a seminar, or the defense also one time asked for the resetting of the case, there is no violation of the right to speedy trial. Now, among the cases I assigned to you, I think you have to take note of the case of Roberto Almario versus Court of Appeals, because in that case of Almario, guys, in that case of Almario, the court ruled that there's really no violation of the right to speedy trial because the delay there is not unreasonable. So you have to determine, because if the delay is not unreasonable, meaning the delay is caused by valid reasons, then usually the court will grant motion for reconsideration in order to reinstate the case. Okay? Because the general rule is, once the case already terminated or once the case is dismissed and the dismissal is tantamount to acquittal, you can no longer file what? You can no longer file motion for reconsideration, you can no longer file appeal, you can no longer file petition for certiorari. But in this exception, which is violation of the right to speedy trial, if there's really no delay, then usually the court will grant motion for reconsideration. Now, again, I have to emphasize that this is what? This is another exception, because the dismissal here is with the express consent of the accused. Okay. Third, usually the third exception is if the accused is discharged as an accused because he is being admitted by the government to be a state witness. Now, for an accused to be a state witness, there must be at least two accused. Hindi pwede may state witness kung siya lang isa. So, there must be two or more accused in order that at least one of the accused will become a state witness. Now, you remember when we were discussing the right against self-incrimination, the government usually will grant immunity, transactional or use and fruit immunity, to a person who is willing to become a state witness. So, the moment that accused is granted approval by the court to become a state witness, then that is also tantamount to acquittal. Now, so how that usually happen? Now, if there are two or more accused, the prosecutor who believes that they cannot prove the case or they cannot prove the guilt of the accused beyond reasonable doubt because for lack of material or relevant evidence, they will explore the possibility of taking one of the accused to become a state witness. And usually the one being taken in to become a state witness is what? The least guilty. The least guilty. And they can no longer find any other evidence aside from taking the accused as a state witness. Because if there are other evidence available, or other testimonies available for sample, of course they will not take the accused as one to become a state witness. So, what will happen now? The prosecutor will what? Will make a motion. And that motion of the prosecutor is with the express consent of the accused. Because the accused cannot be compelled against his will to become a state witness. Remember, anong term ko sa state witness? That is officially the term for traidor. So, matraidor siya kontra sa iyang mga upod. Upod siya na robbery, upod sila nagpatay, whatever crime they have committed. And then, one becomes a traidor. No? So when that happens, it is with the express consent of the accused. And once it is granted by the court, the accused will be discharged. He will no longer be called an accused. He will be discharged, and that discharge of the accused is tantamount to acquittal. As long as the accused fulfilled his obligation in the agreement, anong obligation sa accused sa agreement nila? To testify against the other accused. So as long as he testified in court, and usually sa testimony na may prepared judicial affidavit man na, so hindi ba siya kapagusto kung anong balon niya, or di ba siya shall we say, he will just say anything against, or anything that will not be that will not really be beneficial to the government, because there's also the so-called judicial affidavit. So as long as that accused who turned state witness testified in court, regardless of what happened during cross-examination by the defense counsel, then the accused is considered to be validly discharged, and he will be protected by double jeopardy. Now, among the cases I assigned to you, there's one case here which illustrates that. The case of People of the Philippines versus Carlos Feliciano, wherein one of the accused was discharged to become a state witness. And the court said, yes, he will be protected by double jeopardy. Okay, so you know already the three exceptions. So I would like to summarize. The first exception is what? The first exception is that the case is dismissed because what? Because due to insufficiency of evidence. Okay? And then the second exception is what? The case is dismissed because there is a violation of the right of the accused to speedy trial. Okay? And the third is what? One of the accused is discharged because he becomes a state witness. You get it? Okay. So I would like to reiterate the general rule. What is the general rule now? No, as far as the dismissal is concerned. The general rule is, if the accused is acquitted, or the case is terminated in the manner which is tantamount to acquittal, there is no motion for reconsideration allowed, there is no appeal allowed, there is no petition for certiorari allowed, because that is tantamount already to what? That is tantamount already to acquittal. So it is immediately executory. That is the general rule. Okay? Now, for that general rule, there is an exception again. Okay? And what is the exception? The exception is if the government or the private complainant, meaning the victim or the family of the victim, is denied fair opportunity to present evidence. Meaning they were denied due process to present evidence. And I am talking here of the case of Marciales. Okay? In that case of Marciales, the government wants to take in one of the accused to become a state witness. However, the prosecutor is grossly what? The prosecutor is grossly negligent. No, the prosecutor is grossly negligent. He is not presenting evidence to prove his motion or to support his motion that one of the accused is actually eligible to become a state witness. So, excuse me, without that state witness, the evidence presented by the prosecutor is insufficient. So what the defense counsel did was to file a motion to dismiss in the nature of the mirror to evidence. And the court dismissed the case because there's really insufficiency of evidence. And of course, they filed a petition for certiorari before the Supreme Court asking the court to declare that the dismissal of the case is null and void because there is a denial of their opportunity to present evidence. If you look at this case, the prosecutor really was grossly negligent. And the Supreme Court, in that case of Marciales, granted the petition for certiorari, saying that there is really a denial of the private complainant's right to due process. Okay, so that's one of the exception wherein they were allowed to file a petition for certiorari. Now, take note also that motion for reconsideration is also allowed if there is really no violation of the right to speedy trial. So you have also to consider this, as I was telling you before, if there is really no violation of the right to speedy trial, then the court usually grants motion for reconsideration. So that case I mentioned to you regarding granting of the motion for reconsideration. So take note the case of Roberto Almario. Now, another exception here is if the dismissal is made with grave abuse of discretion on the part of the judge. Okay? So what do I mean by that? For example, if the judge relied on the evidence presented by the defense, which evidence, for example, is inadmissible because they are hearsay, or they are under the rules of evidence, they are not supposed to be admitted, and the judge relied on that for the dismissal of the case or for the acquittal of the accused, then it's possible that there is grave abuse of discretion. Therefore, the case can be subject to either the granting of the petition for certiorari. So I repeat, although the general rule is if the accused is acquitted and the case is terminated, the termination is tantamount to acquittal. Supposedly there is no appeal, there is no motion for reconsideration, or there is no petition for certiorari. However, take note, there are exceptions being mentioned as I previously discussed. Okay, the next question you're going to consider is what? The next question you're going to consider is what are the offenses or crimes covered? Because it's not a question simply of refiling a case, What are the crimes covered in double jeopardy? So number one, identical offense, meaning exactly the same offense. So if you are acquitted or convicted before of homicide, they cannot refile the case of homicide against you, for the same act that you have committed. Amo nang tawag nilang identical offense. Second, any attempt to commit the same or frustration thereof. For example, you were acquitted of prostrated homicide. They cannot charge you later on of attempted homicide. So any attempt or frustration of the same offense committed with the same act is covered by double jeopardy. Third, for any offense which necessarily includes or is necessarily included in the offense charged in the first case. So you know very well, it's only a question of passive and active voice. No? So if you say necessarily includes, that's active. If you say is necessarily included, that's passive voice. So for example, homicide is necessarily included in murder. Or you make it active, murder necessarily includes homicide. No? So, meaning, if you are convicted of homicide, they cannot refile the case for murder later on. Or if you are acquitted of murder, they cannot refile a case of homicide later on. That is covered in double jeopardy. No? So you have to take note of the crimes covered. Now, however, at this juncture, I want you to take note, no? I want you to take note that there is what you call the doctrine of supervening, event, no? Which is some sort of an exception to the crimes covered. Because here, if you're talking about supervening event, no? There are three classifications mentioned in the rules or in the revised rules of criminal procedure. Letter A, the graver offense developed due to the supervening facts arising from the same act or omission. So what do we mean by that? For example, you were charged with serious physical injuries. Okay? And upon arraignment, you pleaded guilty to the offense charged. And then you argued that there are actually two mitigating circumstances. No? The voluntary surrender and plea of guilt. And because of that, you entered the plea of guilt. No? You were sentenced. And after sentence, after promulgation, you immediately serve sentence. In the meantime, during trial, the victim actually was hospitalized. No? He is confined, for example, in the hospital. What happened if, while serving sentence, for example, the victim died due to the wounds that he suffered? Meaning, nag-complication ang wounds, no? That he suffered because of your act in inflicting those wounds. So napatay siya. And then sa napatay siya, you were already serving sentence, no, in jail. Can the government file a case for homicide against you even though you were already convicted for serious physical injury? The answer is yes. Because that's one of the factors, that's one of the situation covered by the doctrine of supervening event. The graver offense developed due to the supervening facts arising from the same act or omission. So it's very clear that the cause of death or the proximate cause of death, no, was due to the wounds that you inflicted on him. But if the cause of death is foreign, without any relations, like for example, he was hospitalized, no? And then, he was hospitalized, and then while he is being transferred, for example, from the room to the ICU, there was an accident, no? Nga nahulog siya, for example, sa bintana. Or nabuyan nila ang wheelchair or whatever, and then napatay siya. Then there will be no application of the doctrine of supervening event because the cause of death is entirely foreign, no, not related to the wounds, for example, that you incurred, but it was really because of accident. Okay. The second situation of supervening event is the facts constituting the graver offense. No? The facts constituting the graver offense arose or were discovered only after the filing of the former complaint or information. At the time the prosecutor filed the information, he was not aware that the victim was already dead or the victim already died. And so, the accused was arraigned, only to find out that after arraignment, the victim actually died the day before the prosecutor filed the information. So, is it possible that the accused will be re-arraigned? Meaning, he will be arraigned again for homicide because the victim actually died, even though the victim died before the filing of the information? Yes, because the prosecutor was not aware that at the time of the filing of the information or the complaint, the victim has already died. Third situation. The third situation here is what? The plea of guilty to a lesser offense was made without the consent of the prosecutor or the victim. So, this is a situation actually of plea bargaining. So like for example, in the case of murder, the defense believes that they don't have really enough evidence to put up a valid defense. And they know really that the accused will be convicted. So the defense counsel will propose what you call a plea bargaining offer. So they will offer to the prosecutor that they are willing to enter a plea of guilt to the lesser offense of homicide with two mitigating circumstances. So, that plea bargaining proposal must be approved by the city prosecutor and must be signed also by the victim's family, meaning representative of the victim. Because obviously the victim will not be able to sign it because he's already 6 feet under the ground. So, the victim's family must sign, the prosecutor or the city prosecutor or the provincial prosecutor must also sign it. So there must be two signatures. If the plea bargaining proposal lacks any one of those two signatures, then there is no valid There is no valid plea bargaining. Even though the accused was rearraigned for homicide because of the plea bargaining proposal, if it is found out that it lacks one of the signatures, meaning that of the city prosecutor or the victim's family, then the plea bargaining is not valid. So they can ask that the case will be reinstated for murder, and there will be no double jeopardy, because the requirement of the law is that there must be two signatures appearing in the plea bargaining agreement, that of the head of the prosecutor's office as well as the victim's family. However, the law also provides, if it can be proven that the victim's family receive a subpoena for them to appear on that specific time and date for the approval of the plea bargaining proposal, and there's proof that they were able to receive the subpoena and they were not able to appear on that specific time and date without any valid reason, then the plea bargaining proposal and agreement is considered valid even though there is no signature by what? There is no signature by the representative of the victim's family. That is an amendment now under the revised rules of criminal procedure. Okay. Now, the next topic that we're going to discuss here under double jeopardy is the so-called identity of the act, no, versus identity of offenses. Now, you have to be aware that it is possible that a single act may what? A single act may result to two kinds of offenses. No? It's possible. A single act may result to two kinds of offenses. And if you are charged with two offenses, then there will be no violation of double jeopardy. Okay? Example, no, for you to be able to really get it. You were caught with what? You were caught with possession of what? Possession of a firearm during the period of COMELEC gun ban. Okay? So what will happen? The government will charge you with two offenses. The first one is illegal possession of firearms. Okay? And the next one is for what? For violation of COMELEC gun ban. So, if you notice, your single act of possessing a gun will give rise to two offenses: illegal possession and violation of COMELEC gun ban. Now, there is no violation of double jeopardy there. Why? Because if you notice, you violated two kinds of laws or two provisions of a different law, a special law or a general law. Or for example, if you're talking about election code or revised penal code. Or it's possible also that you violated one provision of the revised penal code and a special law. So there will be no double jeopardy in that kind of what? In that kind of situation. Another example perhaps is what? You sideswipe, for example, you sideswipe a person and instead of helping him, nalagyo ka. So the government will charge you of two kinds of offenses or two kinds of crime. And what is that? The first one is reckless imprudence, for example, resulting to physical injuries, either serious physical injury or less serious physical injury depending on the injury. And then another one, the government will charge you with abandoning one's victim. So in that case, you will notice that your single act, no, or continuous act, for example, resulted in what? Resulted in two kinds of offenses. So you must be able to distinguish whether a single act will give rise to two offenses or two crimes, no? Because when you are able to do that, then you will be able to conclude na wala asang double jeopardy. Okay? And usually, ang clue mo sina whether there are two provisions of the revised penal code na gin-violate or gin-violate ang revised penal code or a special law or two kinds of special law. No, it's possible nga there are two kinds of special law nga gin-violate simply by a single act. No? So, there is no identity of offense there because in the first place, it resulted into two kinds of crimes. Okay? However, I want you to be very careful. Wala ako ni madala last time sa akon nga post ko sa Facebook. no? There is what you call inseparable offenses. Ang ining inseparable offenses, for example, they cannot be subject of two separate prosecutions because hindi sila pwede ma-separate. So you can only charge them of one offense, no? If you will charge them of two offenses, that will be violation of the revised rules on criminal procedure, specifically on Rule 110, Section 13, which is splitting into two kinds of offenses nga hindi mo pwede ma-split. So, example, in drugs cases, for example, hindi pwedeng i-separate mo ang smoking kag possession. I-charge mo sa smoking and then i-charge mo man siya possession. So, duwa ka case ang i-charge mo sa iya. They are inseparable offenses. So, you have to charge him only of one offense. Kung i-charge mo siya sa duha, then there will be the so-called protection of double jeopardy kung na-convict sa isa and then i-charge mo pagid siya sa isa, i-put up yung defense of double jeopardy. In your criminal law, I'm sure you heard about this. Stealing, for example, several things from the same person on the same occasion. So, stealing of several things on the same occasion, gintakaw mong libroya, ang whiteboard pen niya, ang iyang highlighter, ang iyang ang iyang notebook, etc., etc. On the same occasion, so hindi pwedeng i-charge mo siya separately for each thing nga gintakaw mo because that will be considered inseparable offense. Okay? Next one, you have to be very careful. This is what you call under Article 365 of the Revised Penal Code, I mean. What is Article 365? Reckless imprudence cases, no? Or those cases committed not because of deceit, no, not because of intentional intention to really harm, no, but because simply of negligence. That's why it is called reckless imprudence. And usually sa reckless imprudence cases, no, the reckless imprudence cases, it may result to different kinds of injuries. Because usually, it's possible nga damo ang victims. So, may ara na patay, may ara ang napilasan lang. So, serious physical injury, less serious physical injury. May ara ang damage to property because nabungguan ang iyang kudal, ang iyang salakyan, ang iyang ido, no? Kag ang iyang whatever ang nabungguan. So, damage to property. So, in these kinds of cases, no, under Article 365, there must be only one case filed regardless of how many victims or regardless of what are the injuries or what are the damages nga nag-result. That's why kita mo ang title ng case is Reckless Imprudence Resulting to Homicide, no? Or reckless imprudence resulting to less serious physical injury or reckless imprudence resulting to damage to property. So, there must be only one case filed. Okay? One case filed. So, ano meaning siya na? Hindi pwedeng i-separate mo. Like, for example, reckless imprudence. Ang isa ka case mo, reckless imprudence resulting to less serious physical injury. Ang isa naman, reckless imprudence resulting to homicide. And then, ang third one, reckless imprudence resulting to damage to property. If the government filed 3 cases, tapos mautak ang defense counsel, nag-plea guilty sila sa reckless imprudence resulting to damage to property, then, the 2 other cases are already barred by double jeopardy. Because according to the Supreme Court, there is only one case And that case is reckless imprudence, regardless of the consequences o regardless of the damage and the injury. So, ano ang implication? Kung one case lang, but specifies ang government nga amoni ang natabo. So, reckless imprudence resulting to homicide. No? O one case lang na. Resulting to homicide, less serious physical injury, damage to property. So, tanan. And the penalty will be imposed based on the numbers of victim. But there must only be one case. No? I don't know if you heard the famous case of Jason Aguilar Ibler. No? November 17, 2010 or 29. No? Basta Jason Ibler nga ang first case niya gin-file sa iya sang prosecution is reckless imprudence, no? Resulting to slight physical injury. Tapos ay kadua reckless imprudence resulting to homicide and damage to property. Duha ka cases ang gin-file sa iya. No, it was a blunder on the part of the government because nag-plea guilty sa reckless imprudence resulting to slight physical injury. So that automatically bars, no, the subsequent case of resulting to homicide, reckless imprudence resulting to homicide and damage to property. Because according to the Supreme Court, there must only be one case filed under Article 365. You cannot split, no? Because the moment you split nga ang reckless imprudence happen only on that same act and on that same occasion, hindi mo siya pwede ma-split. Okay? So take note of that. And also in that Ibler case, the Supreme Court said that ang Article 48, you remember Article 48, complex crime, nga a single act may result to two or more serious offenses, o kung one crime is indispensable for the commission of the other crime, di ba? Amo na ang complex crime under Article 48. According to the Supreme Court, Article 48 does not apply or cannot be reconciled with Article 365 of the revised penal code. So, now, if a person is being charged, no, under Article 365 and that is for reckless imprudence, then isa lang kita case pro karga mo na tanan, no, kung may napatay, kung may napilasan, may damage to property, dira mo na karga sa one case nga na, no. Otherwise, no, those cases nga gin-file mo will be barred by by the provision of double jeopardy. Okay. Now, however, amo nang inambal ko nga it's possible nga if an act results to two offenses or two crimes, no, wala sang double jeopardy, there is an exception to that again. That exception, no, is specifically stated in the Constitution. And that is what? If an act is punished by a law and an ordinance. No, exception na, meaning, supposedly, if you follow the general rule, kung inapunish siya sang law, kung inapunish sang ordinance, wala sang double jeopardy because duha ka provisions ang law ang in-violate niya. Pero under the exception, nabutang sa Constitution niya kung if an act is punished by a law and an ordinance, then, no, the conviction or acquittal under either shall constitute a bar to another prosecution for the same act. It is specifically provided in the Constitution that if an act is punished by a law and an ordinance, any conviction or acquittal in either of them in a law ordinance will result to the setting in of double jeopardy. It is an exception because, as I said, kung i-follow nato ang general rule tani, wala na dasang double jeopardy because duha ka law or duha ka provision sang law ang nagapunish. But it is specifically provided in the Constitution nga kung ang isa nga nagapunish sa iya ordinance, then double jeopardy will set in. Like for example, you were charged with theft under the revised penal code, and then another one, gin-charge ka man sa violation of ordinance under sa city ordinance because ang intakaw mo street light. No? So may ordinance kaya hindi pwede takawon ng mga street light. Karon ang penalty sa ordinance na ba lang. For example, ang penalty is only a fine of 1,000. So nag-plea guilty ikaw sa violation sa ordinance, nagbayad ka fine nga 1,000, hindi ka na pwede nga i-charge under the revised penal code because that is an exception, no, provided by the Constitution, that once it is being punished by a law or an ordinance, so any acquittal or conviction in either will bar the prosecution, no, for the other, no? So it is very clear in the Constitution. Okay? Now, so ano pa ang nalipatan ko? I think that's all for double jeopardy. Now, I want you to take note of the cases, no, in your list of cases because they are very helpful, no, in understanding the different aspects of double jeopardy. So for example, in the case of Eduardo Quezon, no, take note ang in-promulgate sang judge sa case nga nagin-promulgate ya lang when the decision came out. For example, ang in-promulgate yang civil aspect lang sang case. No, wala yung in-promulgate ang criminal aspect nga imprisonment. Wala yung lang patuman. So later on, gin-orderan sa sang court nga i-promulgate ang criminal aspect. And the Supreme Court said there's no violation there of double jeopardy. Okay? Now, in the case of Manantan, no, in the case of Manantan, take note, there is no double jeopardy if even though you are acquitted, no, this is a case also of reckless imprudence. Even though you are acquitted, no, if ma-appeal ang government o kung ang prosecution sa civil aspects ng case, there is no double jeopardy. Remember, for every criminal act, there is a corresponding civil aspect of that. So, karon na-acquit ikaw. Pero, pwede sila ka-appeal sa civil aspect. Why? Because sa civil aspect, lain ang amount of evidence required. It does not require proof beyond reasonable doubt. It only require preponderance of evidence, no? So mas lower ang degree of evidence niya kinanglan, no? So that's the case of Manantan, no? I mentioned already the case of Feliciano, ang case ni Marciales, no? I also discussed the case of Marciales during the lecture I have. Now take note of putot, nga ang lain ang putot sa Marciales, no? Take note ang putot, guys, wala saya nag-plea bargaining, no? Kundi nag-admit siya, no? Or nag-plea guilty siya with two mitigating circumstances, tapos wala siya nag-appeal, nag-serve sentence sa dayon. So it is a valid mode of termination because it is a valid conviction. Remember, kung ma-plea guilty ka as charged, no, hindi na kinanglan ang signature sang family of the victim because as charged ka, wala ka nag-plea bargaining to lower offense, no? So there is no irregularity on that. That is allowed by law. And then lastly, the case of Astudillo is a unique case because the moment kani nga ikaw ang accused, nangayo ikaw sa motion for reconsideration, no? When you do that, you waive your right to interpose double jeopardy because it is with your consent nga gusto mo i-review because nag-motion for reconsideration ka. So kung gin-review sang court, no, na find out nila nga ang eksakto galing nga qualifying circumstance is treachery, No, hindi abuse of superior strength, kundi treachery, and treachery was proven during trial, then they can amend the decision. There is no double jeopardy there. Okay? So, ano pa again? Anyway, no, if you have any question about double jeopardy, you can always ask that, no, in our page, and then I will just answer it, no, for the benefit of everybody. Okay? So, ano pa kita naliputan ko, guys? No? I think that's all as far as double jeopardy. So, in the next series that we have, I will go to ex post facto and bill of attainder as well as citizenship. But before I will discuss citizenship, I will post what are those cases and law or laws that you should read so that you can meaningfully follow the discussion or the lecture, no, the moment we arrive at citizenship. Okay? Ex post facto and bill of attainder actually is not really that long, no? So, tamaan lagi kalipot. Okay? So, again, happy Easter, no? From my corner in the library, in our house. So, happy Easter. Enjoy. Take good care, no? If sa COVID, ya kinanglan may flattening of the curves. Sa inyo, ya, you have to maintain the curves. No? Don't allow the quarantine to flatten the curves. Because when that happens, then there will be the parade of the drums. Bye-bye!